case within the courtroom. What, if anything, does that have to do with this particular case? And is there kind of like a history going on here that maybe we all should be aware of?
I had evidence that was being excluded from a court case, and I figured out I had a constitutional right to present it, and the court decided I did not. And so, you know, I guess that's where I stand on that, is if your constitutional rights are being violated, you need to have enough gumption to stand up and do something about it. And so, you know, you've seen what happened when I first started standing up, but did it deter me? No. Here we are, and part of what the grand jury is investigating is about what all happened to, you know, what happened leading up to all that. So.
And the importance of the grand jury, why is it so important that the grand juries continue their investigations?
Well, if they don't, government will get away with anything they want. Government will not investigate itself. And so our grand juries were written into law, or into the Constitution, to be the citizens' way to investigate government when government will not investigate itself. That's it in a nutshell. And if we lose that, government will just keep twisting the rules like we've been seeing them do it, until pretty soon they can do anything they want and they'll never get in trouble.
Well, thank you, David. I really do appreciate your time here this morning. It is great again to see such a large crowd here out for this trial today.
Oh.
And again, this is State of Alaska versus ex-Judge Margaret Murphy.
Is counsel of record ready to proceed? We're ready. Okay. Mr. Campion, were you ready to proceed?
I am, thank you.
Thank you. All rise. Superior Court for the Third Judicial District. That's now in session. The Honorable Judge Thomas Matthews presiding.
Good morning, everybody. Please be seated. Welcome. On record?
Right.
All right. Good morning, everybody. We are on record. Did we get the live stream started? All right. Bear with me for a moment. I got it right here.
Thank you, Ron.
Those who've been to these hearings before will remember that we are live streaming, and it takes a moment to get this actually set up. So, just a moment. All right, good morning again, everybody. We are on record in the matter of State of Alaska versus Margaret Murphy, case number 3HO23-00295, criminal. My name is Judge Tom Matthews. We're here in Anchorage today. This is time set for oral argument on a motion to dismiss. A couple of preliminary comments for the parties. First, for those in the public gallery, you'll note that we don't have anybody seated at the other table today, and the other counsel table. Mr. Campion, the independent prosecutor, I was stuck, unfortunately, because of the airline cancellation, so Mr. Campion is on the phone today. Mr. Campion, can you hear us okay?
I can, Your Honor. I just wanted to advise the court, I'm getting feedback. I don't know if that's happening in the courtroom or just on the phone.
It's in the courtroom as well, so I'm going to ask folks, if you are listening in on the telephone line, if you would please mute your phones. And that seems to be much better. Thank you, everybody. So once again, by way of introduction, this is a motion hearing. We're not here to take evidence today. I'm not going to be hearing from witnesses today. This is a time set for lawyers to make arguments to the court based upon motions that have been filed. This is a situation where in every case, citizens, including Alaskans, have the right to have felony charges reviewed by a grand jury under both the federal and state constitution. And an indictment is a statement of the charges against the accused. It is the right of every criminal defendant to have those charges reviewed by the grand jury as a preliminary step in the process. That indictment is simply a determination by a group of citizens that they've determined there is sufficient evidence of a potential crime to move forward. The Constitution, both under federal law and our state law and our court rules, provides for that process. Equally important, though, is that a criminal defendant has the right to challenge the legal sufficiency of the indictment and ask a judge to make a determination that the process was conducted in accordance with established legal principles. Motions to dismiss an indictment are a part of the regular criminal proceedings before the court, and that's what we're here to address today. I will tell you also at the outset that these are important decisions, and it is not my intention to make a decision today. I want to weigh the arguments of the lawyers, reread the briefs, and make sure that I am clear exactly what the parties' positions are and understand exactly what the arguments are. So I will not be making a decision on the record today. I will issue a decision in writing after I have thoroughly reviewed the record. So with that said, we have lawyers on the defense side, Mr. Patuminos and Mr. Robinson, who's going to be arguing today.
Mr. Patuminos will argue the motion, Judge.
All right, Mr. Patuminos, are you ready to proceed?
I am ready, Your Honor.
You may begin. Thank you.
May it please the court, Mr. Campion. Sword and shield. That's how the grand jury has been described since time eternal. Sword because it is a powerful tool of law enforcement. You can't, as a lawyer, go inside the grand jury on behalf of your client. The grand jury has enormous powers to subpoena, to retrieve documents, to grant immunity and compel testimony. It has brought down cartels. It has brought down public corruption. It has brought down the mafia. It is an awesome power. It is a sword. But it is also a shield. It is a shield because in our founding fathers, the king could charge anyone he wanted. And the shield is putting the citizens between someone and an indictment. Because an indictment, whether you are later exonerated or acquitted, will change your life forever. So we no longer live in a country where the king can indict you. It must be a grand jury. Because of the shield function, there have been guardrails, strictures, limitations about the quality of the evidence that can be received so that the shield has a purpose and a strength and a function. So the grand jury, which constitutionally has the power to investigate and which shall never be suspended, investigate is a neutral term. It is a neutral term because it is both the sword and the shield. When a grand jury investigates and exonerates someone, it is every bit as important an investigative function as it is to indict. Different governments have emphasized the sword and shield in a different way. In our state, great emphasis has been placed on the shield function of the grand jury. For me, this is a return to the beginning of my career because I was the first special prosecutor ever appointed in the state of Alaska in 1978, where I served in the special prosecutor's office when it first opened under now Judge Mahalski. I probably convened more investigative grand juries than any lawyer alive. I was designated as a special United States attorney and had the option of conducting investigative grand juries both in the federal system and the state system. Therefore, it was with great interest that I circled back at the beginning of my career when this assignment came my way. The first thing I noticed was the indictment itself. It says that on or about November 3rd, 2022, at or near Homer, 3rd Judicial District, Margaret Murphy committed the crime of perjury. And that's all it says. When I first read that one sentence, not 5 seconds into the case, I was bewildered. When I first came to the Special Prosecutor's Office, I had the opportunity to be sent to the Cornell Institute of Organized Crime, where we were taught and trained how to conduct investigative grand juries. We were put in a scenario like what most lawyers go through in the National Institute for Trial Advocacy, where you learn by doing, and you're placed in front of a mock trial. We were placed in front of mock grand juries, and we were taught the following. There's a triangle. When you have a witness in the grand jury who might be part of the mafia, some sort of witness that you had a difficult task to get to justice on, there was a triangle. You either got the truth out of the witness, you set the record for evasive contempt, which is what happens when a witness appears but refuses to meaningfully answer the questions, or you set the testimony up for perjury. And we would do those drills, and experienced prosecutors would watch us, and they'd say, do you think you have it? Do you think you have evasive contempt? Do you think you have perjury established? Well, let's take a look at your question. Let's take a look at the answer. Let's make sure. No, try again. And the reason is, we were taught that perjury is a technical offense that must have a specific question, a specific answer. They must relate, and evidence that proves the matter false must be clear. So it was something to practice. So when I read this indictment, which says nothing, it says not what the testimony was, and says nothing about why it was false, I was bewildered. I thought, what has happened? Has the law changed? Did my education get legislated away somehow? So I dug into the law. And in an unbroken chain of precedent since 1890 and before, nothing had changed. The law requires specificity with respect to perjury indictments, which clearly delineates what is the testimony at play, why is it false, and give the defendant notice of what you're talking about. So now I was thinking, well, the law is the same, and this indictment says nothing, and it complies in no way with any of the law. What in the world went on here? So then I delved into the grand jury record, and I found my answer. On January 30th, after the grand jury had been told repeatedly that it was not in a position to issue an indictment and would not issue an indictment, and that was not its goal, the grand jury suggested that they might put into their report that they thought perjury had been committed by Judge Murphy. They didn't say what, they didn't say what testimony, they didn't say how. That's all they said, one sentence. On April 7th, when Supreme Court Order 2000 came out, the grand jury said in one sentence, we'd like to consider, on April 7th, an indictment. On April 7th, there was no proposed indictment in front of the grand jury to consider. And so the grand jury, after saying that, said to the independent prosecutor, what do we do now? And the independent prosecutor correctly said, I need to draft an indictment. I need to instruct you on that indictment and on the law. And then we will come back and we will consider the indictment that I draft. That was the plan. That was the last day that the grand jury had a quorum. The next proceeding, there were 11 grand jurors, and as the prosecutor himself said repeatedly during the grand jury process, once we get to 11 grand jurors, the grand jury can do nothing. At that point, the independent prosecutor drafted a grand jury indictment that said the only thing that it could say, because he had not been apprised by the grand jury of anything other than, we'd like to consider an indictment. For what? For when? They didn't say. So the indictment that was drafted could say no more than what the grand jury, when it had 12 jurors, said. And he asked the grand jury of 11 to then vote on this indictment in clear violation of the Constitution, Criminal Rule 7C, and the requirements of specificity. And that's the indictment that's before you, and now the mystery is solved. It was done this way because there was an attempt to evade or get past the problem that the grand jury lost its quorum. But the indictment is no less defective for the attempt to get around that problem.
While you're pausing, can I ask you a question?
Of course.
Can that issue be resolved if all 12 grand jurors are reconvened?
No,
And tell me why.
because of Stern, and because of the record as we have it. And perhaps this is a apt segue into discussing Stern.
But before you get there, let me ask this. I think this was clear, and this may be a question for Mr. Campion, but I want to ask your opinion as well. You have laid out in your brief 4 different arguments as to why this indictment ought to be dismissed. Is it sufficient for the court for me to dismiss or to grant the motion on any one of those grounds, or must I look at all 4?
That's a very astute and important question, and there are layers of the answer. The simple answer is yes. Every single one of these defects by themselves are sufficient to dismiss the indictment. However, it's important for the court to review the record as a whole, because the errors are cumulative. What's a good example? Under the Stern test, as the court is aware, you have to make an analysis of whether there is sufficient evidence, apart from the offending evidence, apart from the inadmissible hearsay and the unprecedented amount of detritus that's in the record, and determine if there's sufficient evidence to sustain the charge. But what is the charge? You don't know, because the indictment is defective. As to what testimony do you apply that test? You cannot, because the indictment is defective. On what law did the indictment, even as it was, issue? No instructions. The prosecutor, way back in January, read the term knowingly, explained to the jury that testimony given about events that took place 20 years ago had to be knowingly false at the time it was given. The testimony must be knowingly false. What's the testimony? We don't know. So you can't apply Stern because the indictment is defective. You can't uphold the indictment because the instructions are bad. You can't uphold the indictment because there is an unprecedented amount of material here that had no business being in a grand jury. And there's another reason why I believe the court should address all of the issues. There is a woman named Harper Lee. Harper Lee attended and studied law at the University of Alabama as a woman in the late 1940s. One can only imagine what it was like for Harper Lee to study the law in the 1940s in Alabama. She never became a lawyer, but She probably inspired more young people to become lawyers than anybody you can name. Because she wrote a book that we all had to read when we were young called To Kill a Mockingbird. And it is about Atticus Finch. And it's about the honor and duty of being a lawyer in the face of public approbation and pressure from the outside that threatens to destroy our rule of law. And how Atticus Finch held the line and did his duty. Not every case that we encounter as lawyers bring in the concepts that go with To Kill a Mockingbird and Atticus Finch. But Judge, this is one of those. This is one of those cases where it is important for the court to write well about all of this. Because in well nigh of 2 years shy of 50 years practicing law, this lawyer in front of you has never seen anything like it. It is the biggest incursion on our rights to grand jury indictment and to fair proceedings that I have ever seen. And it threatens the very fabric of what it is that our founders stood for when they took the power away from the king. It's a long way of saying, regardless of the technical ability to dismiss this indictment on some narrow ground, on quorum, on the legal facial insufficiency of the indictment, I urge you not to do it. Because there is a judicial function at play here, where the judiciary educates, sets precedent, teaches, informs the government as to what it can do and what it cannot do. And while it's not always implicated in the cases we undertake, it's implicated here. This indictment violated the rule that the evidence before it must be admissible. Intentionally inadmissible evidence was introduced in volume. We've attempted to lay some of it out for you. There is much more, it is much worse. And all you have to do is skim the exhibits to the grand jury and you will see the wrong sufficiency of the evidence instruction was given to the grand jury. In fact, the sufficiency of the evidence instruction was the lowest standard of proof that exists under the law, which is far from what's required. The grand jury didn't have the proper quorum. The indictment failed to specify the crime in violation of Rule 7C. The rules that implement our constitutional right and that makes the grand jury a shield were torn asunder. The shield was in tatters. It's too late for Judge Murphy, who now has suffered the consequences of an inappropriate, illegal, and unfair proceeding. But there's a silver lining here. And the silver lining is that cases like this stop the bleeding. It stops the threat and the danger that can ensue. When Supreme Court Order 1993 came out, and the court clarified, and I say clarified because it wasn't new law, that parties elected to nothing by no one do not have the right to come into the grand jury and start the hunt. We are a representative democracy. That means that our representatives, the executive branch of government, is the sole authority to institute charges, and they must take it to the judicial branch. And as the O'Leary case tells us, a grand jury is part of the judicial branch of government. Mr. Campion, though he says otherwise, does not represent them. He is in the executive branch. He is an executive branch agent. All of these concepts, which are fundamental to the shield function of the grand jury, are before the court now. And I believe need to be redressed, reaffirmed, and solidified. Because this is one of those cases, like Atticus Finch and Harper Lee was talking about before she won the Pulitzer Prize and received the Presidential Medal of Freedom for her writings. This is such a case. Subject to the court's questions, I'm done.
Thank you. I may have further questions for you after I've heard from Mr. Campion.
I'll be happy to address them.
Thank you. Mr. Campion, good morning.
Good morning, Your Honor.
It's your turn.
Okay, well, I guess I'll start, Your Honor, by reminding the court that the instructions that I received, the evidence that was presented to the grand jury, the questions that the grand jurors had in the course of the proceedings are all accurately reflected in the record that has been submitted to the court. Further, my arguments as outlined in my opposition, I won't repeat them. I believe that this time is best used to address Mr. Bituminos' arguments and also to address sort of the intent that led the intent of the grand jurors as I understood it and my intent as it led to the indictment. Factually, there's very little I disagree with Mr. Bituminos. I think he accurately reflected what happened in terms of the facts, but I think it's important for the court to consider, particularly in light of the record of the grand jury, that the grand jurors were not intending to set up Judge Murphy for perjury or for any crime, that at the time that Judge Murphy testified on November 3rd, 2022, the grand jury wasn't viewing her as a target of its investigation. It was not viewing her necessarily as someone that they expected would be evasive or would not be truthful in her testimony. I think the record is clear that when she testified on November 3rd, she and the grand jurors understood she was testifying about what happened during Mr. Haeg's trial in 2004 and 2005. And very clearly, the grand jury was not planning to indict Judge Murphy or anyone else in November 2022. It wasn't until January 2023 when the grand jury received some correspondence between Judge Murphy and the Alaska Commission for Judicial Conduct that there appeared to be a discrepancy between her testimony and what she had written to the commission. And that's what led to the further discussion of potential perjury charges, including the instruction that I provided. Our position is that the grand jury, or I should say my position, is that the grand jury was adequately instructed on the elements of perjury as well as the mens rea requirement. That was done in January. But I can't dispute Mr. Bituminos' comments and argument regarding quorum. The record is clear that both myself and the grand jurors understood that they needed to have at least 12 grand jurors to effectively function as a grand jury. I want it to be known that whatever led to the decision for the grand jury to convene an investigative grand jury all occurred before my appointment in August 2022, and I viewed then, and I've always viewed that my role was to advise and guide the grand jury through the proceedings, and I think the record shows that I advised them of the potential risks of all of their decisions. I think it's important that when this indictment was returned back in April 2023, I advised the Superior Court at the time that I had very serious concerns about the indictment at the time, and I advised the court to potentially take under advisement whether or not to publish the indictment because I shared Mr. Bituminos' concerns. Nonetheless, the Superior Court decided to return the indictment without any further review, and it led to where we are today. If the court has a question about whether, for example, if the court were to send this back to the grand jury, whether or not it would be valid, I don't know the answer to that question, but I think practically it's unrealistic. We lost one of the grand jurors, and as far as I can tell, he's not someone that we can find to reconstitute the grand jury, even though the grand jury has not been, their service has not ended. Ultimately, my position, Your Honor, is that I've laid out our response to Mr. Bituminos' arguments. I understand the court has discretion regarding the motion to dismiss. I think it's important for the record to reflect that the pleadings here do not accuse the grand jury of acting with bias, ill motive, or inappropriately targeting anyone, including Judge Murphy. I think the record shows that this is not a matter of myself as whether or not I'm a member of the executive branch. There was no attempt by myself or by the grand jury to set up anyone, including Judge Murphy. And I slightly disagree with Mr. Bituminos that in this circumstance that the grand jury didn't do its job. I think the record shows that these were a group of people who conscientiously heard evidence. They tried to do their best under very unusual circumstances, and they led to the decisions that they made. I do recognize the technical challenges that are presented by this indictment, and I defer to the court regarding this motion to dismiss.
Let me ask you, Mr. Campion, the question that I had posed to Mr. Tuminos earlier, because there are 4 grounds for dismissal that he has laid out in this motion. Is it sufficient for me to grant the motion if I find that any one of those are true?
Yes, Your Honor.
So, for example, if there's no dispute between the parties that the grand jury lacked a quorum at the time the vote was taken, if that's dispositive, it means I grant the motion. Is that your view as well?
Yes, Your Honor.
You have laid out arguments that, well, the grand jury at least heard all the evidence and voted to indict, even though they didn't have the written indictment in front of them. Do you want to expand on that?
Sure. I think I agree with Mr. Petuminos that the indictment itself was not presented on April 7th, but on April 7th, when the grand jury voted, the record shows that they had already been instructed on the elements of the crime of perjury. They had received admissible evidence regarding the potential charge of perjury, and they had a quorum when they made that decision to indict. Mr. Petuminos is correct that they didn't illuminate further, but I think the record is clear as to what the basis of the alleged perjury was. And I will stand on my argument that if the court believes in any way that the indictment itself was deficient, I believe that a bill of particulars can cure that.
A couple of other questions. You referred to, at least I believe what you're talking about is the return of the indictment in April of 2023 that was done before the Superior Court in Kenai. Is that what you're referring to?
Yes, Your Honor.
And that was where the argument at least was laid out that potentially there were, at that time there were 11 grand jurors, and that was laid in front of the Superior Court judge down there at the time, right?
I believe the record reflects that. That was my intent, Your Honor.
And the record, I think, also reflects that the judge indicated that that ought to be addressed by motion, and here we are.
That's correct, Your Honor.
And so here we are on that point, correct?
Yes, Your Honor.
To the point that I think you've raised that the grand jury lacked the 12th juror, are there steps that have been taken, or are there steps that could be taken because the grand jury has not yet been discharged to secure the attendance of that 12th grand juror and remedy the defects that have been outlined in the motion practice?
Your Honor, I assume that question was directed to me, and I will answer that. I believe reasonable steps were taken in April 2023 and subsequently by the jury clerk in the Kenai court system, as well as officers from judicial services, to try to locate that 12th juror and to implore him to continue his service until completion. Those efforts were unsuccessful, and as Mr. Petuminos suggested, there was some discussion among the grand jurors about other steps that could be taken. Ultimately, they decided with my counsel not to take any, or not to suggest any other extraordinary steps. For example, having him arrested or having a citation issued or anything like that.
All right. Anything else that you wanted to clarify in response to my questions, Mr. Campion?
No, Your Honor. Thank you.
Mr. Petuminos, any follow-up?
Yes. Behind Mr. Campion's remarks is a fundamental misapprehension of the roles of government here. It is not that the grand jury sought to set anyone up. It is that in order for a perjury charge to issue, as the United States Supreme Court and all the federal courts and all the state courts that have considered the issue have said clearly, and we set them forth in our brief, there must be a specific and clear question, a specific and clear answer, and sufficient evidence of its falsity for a perjury prosecution to ensue. So it's not that you try to set someone up, it's that you need to have the proceedings in front of the tribunal that are required to match the elements of a perjury prosecution. The laissez-faire role that the prosecutors took in these grand jury proceedings are unprecedented. It is not for the grand jury to decide for themselves with no help and no member of the bar with a license and with a code of ethics and all that goes with it, to run off willy-nilly by themselves. Because that is the role under the minimum standards set by the bar, by the ethical code under which we all operate. And it's a tricky business because when a prosecutor is in there by himself, he is in an ex parte proceeding, isn't he? And it's his obligation or her obligation to make sure that the sword and the shield are in balance and that the law is followed. You don't stay back and say, whatever you grand jurors want to do, because the grand jury is a judicial tribunal. They don't have law licenses. They have to rely on the law as given to them and the judgment as given to them by the prosecutor. And much has been written about this. So behind Mr. Campion's comments are this notion, I was just there assisting the grand jury for what they might want to do. That's just all it was. And you read Order 1993 and it lays it out. And it's not news. It's not new. The prosecution function, the executive function of the executive branch of government, brings to the judicial body, the grand jury, its case. And if there's more to investigate, they investigate. And the guardrails and the constraints and the careful conduct of those proceedings are the responsibility of the executive branch. When I was a prosecutor, there was a term called runaway grand jury. Maybe you've heard of it. A runaway grand jury is a grand jury that takes off on its own, violates the law, does whatever they want, and the prosecutor can't stop them. Do you know what happens? 5 minutes after the grand jury issues its indictment or result, the executive branch dismisses the case and it doesn't have to ask anybody. Because it is an executive function to prosecute, a judicial function to review the material, and then it's an executive function up until a plea of guilty is taken or until a jury verdict is returned by the petty jury. The prosecution doesn't have to ask anybody. And this notion that the grand jury can run off on its own and do whatever it wants, and the executive branch is powerless to stop it, is simply wrong and scary and frightening. And that's why I hope you don't just write an opinion saying, oh, 11 grand jurors, too bad, because there's so much at stake here. Thank you.
Thank you, Mr. Continuous. All right, folks, that concludes the arguments for today. As I indicated at the outset, my intention is to review things thoroughly. I will be issuing a written opinion in this case. I'm not giving an answer here today. My expectation is that I will get that opinion out in the next 30 days. I would like to set at least a follow-up hearing to keep this case on track. Next phase, if the motion is denied, would be a trial setting conference, and so let me set it on, if I may, February 22nd at 10 a.m.
Yeah, that works, Judge.
All right, Mr. Campion, February 22nd at 10 a.m.
That's fine, Your Honor. Thank you.
So that'll be our next hearing. I see a hand up in the back, and folks, this is not a time for question and answer. So unfortunately, I can't answer further questions. This was just an argument among the lawyers today. Thank you for your public participation. I understand that there's interest in this case. I'm glad that we had folks here. I will be issuing a written opinion as I've indicated. That will be a public opinion once it's issued. But those will conclude the proceedings for today. So thank you all for coming. Stay safe, everybody, and we'll be in recess to conclude this proceeding.
Goodbye.
All rise. All rise.
So I'll have all this information that I found in the description and in the pinned comment below. Check out Alaska Watchman. I just found out about this recently. I wish I'd known about it sooner. Remember these two judges right here. This is going to be very important in an upcoming video. The information here is just what I found briefly online. There's a lot more to it. This is a big article right here. Yeah, so this judge is corrupt. She got caught. Thanks for watching. I appreciate each and every one of you. Like, share, and subscribe. And I will catch you on the next one. Thank you.